afternoon and welcome to the Executive Branch Review Conference breakout panel on climate risk as a new regulatory risk, implications for financial regulatory control of the financial system. My name is Jeff Wood. I'm a partner in the Washington, D.C. office of Baker Botts. I previously had the honor of leading the Justice Department's Environment Division for the first 2 years of the Trump administration, and I currently chair the Federalist Society's Environmental and Property Rights Practice Group, which is a co-sponsor of today's breakout panel, along with our other co-sponsor, the Federalist Society's Financial Services Practice Group. We're really grateful you're here, both in person and those of you joining us virtually. It's my privilege to introduce our distinguished panel and to moderate a vibrant discussion about the legal, policy, and economic merits of the Biden administration's whole-of-government approach to harnessing financial regulatory measures to spur reductions in greenhouse gas emissions, enhance corporate governance, and to drive energy transition in the private sector. Under new approaches adopted since January of 2021, the federal financial regulatory agencies are taking aggressive action to address climate-related financial issues. These government initiatives build on and in some respects complement non-governmental ESG programs, a key focus of some activist shareholders, and increasingly forcing closer corporate scrutiny of climate-related concerns and a focus on broader societal goals as well. One of those societal goals, as expressed by the Biden administration, is a commitment to net zero emissions by 2050, a commitment shared by many companies and industries as well. And many of these financial measures target what some see as material systemic risks to the financial system as a whole and to individual companies as well, so that is certainly subject to much debate. For example, the Financial Stability Oversight Council is taking steps to incorporate climate-related financial risk into regulatory and supervisory practices. We'll be hearing more about that today. The SEC has proposed to require publicly traded companies to disclose company-wide greenhouse gas emissions, including emissions far up and down the supply chains. The SEC proposal would also require disclosure of corporate governance, of climate-related risks, and relevant risk management processes, along with climate-related financial statement metrics, targets, and transition plans. Climate-related actions are also being taken at the Federal Reserve Board, the CFTC, the Federal Housing Financing Agency, and the Treasury Department's Federal Insurance Office, just to name a few. To help us better understand these new initiatives and their legal, policy, and economic merits, we are joined by a distinguished panel of leading experts from both inside and outside government. Our first speaker will be Graham Steele. Graham, welcome. He's the Assistant Secretary for Financial Institutions at the U.S. Department of Treasury. He is an expert on financial regulation and financial institutions. He's a graduate of the George Washington University Law School, and he's held senior staff roles at the Federal Reserve Bank of San Francisco, the Senate Banking Committee, and the Office of U.S. Senator Sherrod Brown. I believe we overlapped on Senate staff around the same time. In his current role at Treasury, Mr. Steele works with Treasury Secretary Janet Yellen on policies related to the regulation of activities of banks, securities, broker-dealers, asset management companies, and other financial institutions doing business in the United States. He was nominated by President Biden and confirmed by the United States Senate in November of 2021. So thank you for being here with us today, Assistant Secretary Steele. Our second speaker is Professor Christina Parajan-Skinner, Assistant Professor of Legal Studies and Business Ethics at the Wharton School at the University of Pennsylvania. Professor Skinner received her law degree from Yale Law School. She's a highly regarded expert on financial regulation, with research focusing on central banking, the financial markets, separation of powers, corporate governance, and law and macroeconomics. Prior to joining the faculty at Wharton, Professor Skinner served as legal counsel at the Bank of England in the Financial Stability Division of the bank's legal directorate. Third, we're joined by Jeremy Kress, Assistant Professor of Business Law at the University of Michigan's Ross School of Business, where he is also the co-faculty director of the Center on Finance, Law, and Policy. Professor Kress graduated from Harvard Law School and from the Harvard Kennedy School, where he was a presidential scholar. His research currently focuses on bank regulation, systemic risk, and financial stability. His written work has appeared or is forthcoming in Duke Law Journal, Northwestern University Law Review, Southern California Law Review, and elsewhere. And finally, we're honored to be joined by Dr. Paul Kupiec, a senior fellow at the American Enterprise Institute. Dr. Kupiec holds a doctorate degree in economics from the University of Pennsylvania. His work at AEI focuses on systemic risk and the management and regulations of banks and financial markets. He also follows the work of financial regulators, such as Federal Reserve, and examines the impact of financial regulations on the U.S. economy. So we're really pleased to have such a distinguished group of speakers this afternoon. With those introductions, let's begin the discussion. Each speaker will provide some brief opening remarks, and then we'll have time for moderated Q&A as well as audience Q&A. So begin thinking about those questions you might have for our panels. With that, let me turn it over to Assistant Secretary Steele.
Thanks very much, Jeff. Thanks for having me here. Thanks to the Federalist Society for hosting this important conversation. So I'm looking forward to the discussion we have after the presentations, but I'm just going to sort of start with some of the initiatives that Treasury is undertaking in the space of climate finance, just so you have a sense of the work that we're doing and how we're thinking about this issue and how climate change intersects with the work of the nation's finance ministry. I think a lot of people don't find that connection necessarily intuitive, but I just want to quote from the Secretary when she spoke at COP26 in Glasgow, which is, she said, "Climate change is not just an environmental issue. It is not just an energy issue. It is an economic development and market destabilizing issue, and I would not be doing my job if I did not treat it with the seriousness warranted." And now, I know we can debate whether folks agree on that set of statements, but that is how the Secretary very much thinks about the role of the Treasury Department within the context of climate change. I think Professor Kress is going to talk a little bit more about some of the specific risks that can arise from climate change and how they impact the financial sector, be it acute or chronic physical risks, the risks of the transition to a clean economy. But you know, we believe that those are some of the sources that intersect with our roles and responsibilities at the department. And I would say we're going to talk a lot, I think, about risks today. We also view the transition as an opportunity, as a chance to use our innovation and our technology to move away from a carbon-based economy and to innovate into new areas of the clean energy transition. And I would note that we are not alone in this view. Financial institutions with assets of over $130 trillion have made voluntary commitments to become net zero by 2050 and to achieve strong science-based interim targets for emissions reductions by 2030. So private sector actors very much view this transition as an inevitability, and we're trying to work with them to further that process. So it is not just the Secretary that thinks that Treasury has a role to play with climate change. We take a lot of our direction from the President in several of the executive orders that he has issued since taking office in January of 2021. The first is Executive Order 14,008, Tackling the Climate Crisis at Home and Abroad. And I think that this is sort of what Jeff was referring to when he says that the administration is trying to deploy and organize the full capacity of all of its agencies to combat the climate crisis and implement a government-wide approach. So essentially the President is saying, agencies, think about what your role is here and the role that you have to play. I would also point out Executive Order 14,030. That is the Climate-Related Financial Risk EO that specifically directs the Secretary to engage with the members of the Financial Stability Oversight Council, or FSOC, and instructs the Federal Insurance Office, or FIO, to address climate financial risks. The last EO I would point out is 13,985, which is Advancing Racial Equity and Support for Underserved Communities through the federal government. That sets forth a number of racial equity goals and support for underserved communities, but calls out the climate crisis and the impacts that it can have on exposing and exacerbating inequities within our society. So with that sort of framework, it is coming from the President on down to the Secretary and then down to the respective offices within Treasury. I'm going to name a few of those specific offices and the work streams they've undertaken in the space so far. The first is the FSOC, which was directed by that EO to work with its constitutive member agencies, and it produced a report last fall on some of the risks involved from climate change from a financial perspective. And here I want to be very clear that there is a role for the Treasury to interact with the financial regulatory agencies in their capacity as FSOC members. However, those agencies are independent agencies. They're independent regulators. We take that distinction very seriously between the political agencies that are in the cabinet and the independent financial regulatory bodies. So let me give some high-level conclusions from the FSOC report. The report has over 30 recommendations for members across four broad categories The first is assessing climate-related risks to financial stability. The second is enhancing climate-related risk disclosures. The third is improving climate-related data. And the fourth is building capacity and expertise at state and local level entities. So this is very much a capacity building and measurement exercise to better understand what the risks are and how the agencies think about those risks. Following the release of the report, we have created a climate-related financial risk committee, or CFRC, that includes representatives of all 15 agencies. And through that committee, they're working on enhanced regulatory coordination, additional climate-related data, scenario analysis, and risk assessments. FSOC is also in the process of setting up a climate-related financial risk advisory committee, or CFRAC. The advisory committee will report to the CFRC to help the council gather information and analysis from a broad array of external stakeholders as well. So it's not just governmental agencies taking part, we're accepting consultation from the public as well. Next, I'll turn to the FIO. So FIO has been working to assess climate-related issues or gaps in supervision and regulation of insurers. It is assessing the potential for major disruptions of private insurance coverage in U.S. markets, particularly those that are vulnerable to the climate change impacts. And third, it is increasing its engagement on climate-related risks with the industry itself to better understand how insurers are measuring and understanding what climate-related risks are and how they feel that implicates their businesses. In the fall, FIO published a request for information, or RFI, seeking public input on these priorities to better inform the work going forward. The RFI received significant input from numerous stakeholders with over 50 unique responses from over 5,300 individual signatories representing over 95 different organizations. So again, we take public input very seriously. We have put some of these priorities out for public comment. Taking in the input that we have gotten, we have formulated a climate-related plan of action for 2022 to advance the 3 priorities that I laid out before about gaps, about looking at vulnerable markets, and about increasing engagement. Number 1, we plan to issue a report by year-end focusing on insurance supervision and regulation with an eye towards an assessment of the gaps in supervision and regulation. Second, we're going to begin a quantitative analysis of the transition risks of insurance investment portfolios and the physical risks of their underwriting of liabilities from property and casual and other climate-related exposures. And third, we will increase our engagement with this sector. We have a federal advisory committee on insurance that has industry members, and we are working on hearing again from them on how they view these risks and what the private sector and public sector can do to address those risks. So that is our plan for 2022 going forward. A report, an assessment of the risks, and in sector engagement. Another piece that I will call out is the Office of Consumer Policy, which leads a 23-member agency commission known as the Financial Literacy and Education Commission, or FLEC. It was a body that I was not aware of until I joined the Treasury Department, but I assure you it exists. The FLEC is looking at climate-related financial risks to households specifically, in particular in low-income and historically disadvantaged communities. The goal there is to understand which communities are particularly vulnerable to climate change, the risks of climate change, and also look at the communities that are most vulnerable from an economic and financial perspective, and essentially to try to map those 2 different geographies on top of one another to understand how specific regions will be impacted by climate change, both from a physical and transition perspective. And from there, again, this is very much a stock take, an understanding, an attempt to quantify what these risks might be. We hope that that will inform other policy processes, both within the Treasury Department and across the government. Think about what tools might be brought to bear to better increase community resilience. The last thing that I will note is the Office of State and Local Governance and Local Finance, because we know that there are a lot of states and municipalities that are going to be particularly impacted, and climate change will not impact the nation as a whole in the same way, in a uniform way. Specific regions will be impacted differently, both from a physical and transition perspective. And so the Office of State and Local Finance has worked with municipalities to understand how they view the risks to their municipal finances from both physical and transition risks, and how Treasury can do a better job of supporting them through municipal funding markets and otherwise. So again, this is kind of a laundry list of the work that we're doing, but hopefully it gives you a sense of how the department's looking at climate-related financial risks I look forward to continuing the conversation with the other panelists.
Thank you, Assistant Secretary Seal. Professor Skinner, for those of you joining us today, you'll actually hear again this evening if you're attending the dinner on the ESG panel where Professor Skinner is also participating. So we're especially appreciative of your support of the conference today and look forward to hearing your remarks.
Well, thank you, and thank you to everyone for being here to take part of this incredibly important conversation. And thank you very much, Graham, for that very insightful perspective from inside the administration. So it's great for us to have that baseline to have a conversation. Now, in my remarks today, I want to focus specifically on the Federal Reserve, the U.S. Central Bank, and why the Fed in particular sits quite uncomfortably within a whole of government approach to addressing climate change that has been articulated and advanced by the Biden administration. So let me give you a little bit of context first. So for many years, while central banks around the world had begun experimenting with various ways to deploy their policy tools to tackle climate change, the Fed had largely held back. But increasingly, in the face of tremendous public and then later administration pressure, the Fed eventually waded in. So it has now joined the Network for Greening the Financial System, which is a consortium of central banks that have dedicated themselves to thinking through how they can deploy policy tools to address climate change. The Fed has issued financial stability reports indicating that it's open to considering how climate change is a financial stability risk in a way that would impact its mandates. And it's established 2 new supervisory committees, both on a microprudential or firm level and macroprudential or system-wide level, to think about how supervisory tools of the Fed might be deployed to address climate risk. But as I've argued in some of my research, it's far from clear that the Fed in particular has a legal mandate to proactively use its various policy tools to address climate change within the 4 corners of the mandate that Congress has given the Fed within the Federal Reserve Act. And I think it's helpful to make this legal point concrete to think through the 3 main statutory responsibilities that the Fed has in the arena of monetary policy, regulation, and supervision. So first, where monetary policy is concerned, the Fed is charged with pursuing price stability and maximum employment. But climate change doesn't really fit in right now. So climate change is not presently impacting price stability, and it's not presently impacting employment. And although the Fed's monetary policy can at times slightly trail developments in the economy, it cannot or should not chase or anticipate hypothetical changes to future price levels. Congress did not delegate to the Fed the power to do that. Now, the Fed is also a bank regulator. It has the power in particular to set capital requirements in this respect, especially in regard to institutions that could pose some financial stability risk given the institution's size and mix of activities. And some suggest that this regulatory authority to set capital requirements could be used to try and move dollars away from brown businesses and potentially toward green ones. But as I've argued, I think it's difficult, at least in the case of U.S. banks and U.S. bank holding companies specifically, to demonstrate that financial stability risk is tied to climate change, at least not in the specific way that we've been using that term in the past 10 years. So risks to financial stability generally come from some kind of credit risk that is lurking on a big bank's balance sheet that if and when that risk materializes, it so damages the bank's balance sheet that their fundamental solvency comes into question. And this, of course, is what happened in 2007, 2008, and motivated some of the provisions in the Dodd-Frank Act. But in order for this kind of moment to happen, to result from climate change, a number of bad things would have to happen first, which presently makes the risk so attenuated that it may well sit outside of what we've been thinking of as an actionable financial stability risk. So in particular, we need to think about the ways that U.S. banks are so incredibly geographically and sectorally diversified that it's hard to see how any given physical manifestation of climate change, like a storm series, for example, could pose this kind of solvency risk. regarding transition risk, policy changes that could drive certain borrowers out of business. Well, again, those policy changes would have to be so sweeping and so sudden that a huge swath of corporate America and households would be unable to plan or adapt. But ultimately, when we're thinking about bank solvency, what really matters is looking at the bank balance sheets themselves. And when you do this, you see that their exposure to the biggest carbon producers is quite a small proportion of their balance sheet, precisely because these banks are so diversified. So in the US, for these banks, their wholesale loan exposures, again, to the big carbon producers, ranges from 7% at the top level to 2% at the bottom range. And we know that banks are every day moving away from lending to these kinds of borrowers. And meanwhile, their equity capital, that loss-absorbing capital, is 2 or 3 times that amount. So again, this analysis is very specific to US banks, and of course it could always change, but I think it's something we really need to incorporate into our conversation about financial stability risk. Okay, so putting that to the side, then there's supervision. While the Fed certainly, no question about it, has the legal authority to supervise banks for all manners of credit risk, including climate risk, to the extent that climate risk is a bona fide credit risk for any given asset, we also need to have in the conversation these important due process concerns. Given how inherently opaque bank supervision can be, there's always the risk that the line between an identifiable credit risk becomes blurred with an aversion to the borrower's business lines. And then legitimate supervisory actions can cross over into politically motivated ones. So we have to be on guard for that as well. All right, so if Congress has not assigned to the Fed a legal role to proactively address climate change, what exactly are the implications for a Fed that pushes beyond the limit of its statutory remit? So I want to suggest there are 3 things to consider in this regard. First, there are some potentially concerning implications for the democratic order. If there is an end run around Congress, this is difficult to square with democratic legitimacy. Climate change poses questions that are polarizing. There isn't a social consensus about what the state should do about climate change, and certainly not about what the Fed should do about it. If there were, Congress would write new laws giving the Fed new goals to tackle climate change, but it hasn't. So we really have to wonder, is this economic engineering, which Congress has not given the Fed a mandate to engage in? And it also suggests that when Congress is inert, the Fed can respond to the president's wishes in the interest of expedience. But that's a very slippery slope to slide down. If you give the Fed the power to identify new financial stability risks, for example, with no limitations on the hypothetical character of the risk or the time horizon along which we're examining risk, any number of things could fall into that bucket. This kind of ballooning of a mandate will certainly become ripe for political abuse in a future administration which has different kinds of priorities. That administration may well ask the Fed to focus on trade or immigration policy as financial stability issues. So second, pushing ahead with climate initiatives could erode the separation between monetary and fiscal policy, which we've traditionally had, which raises delegation questions and ultimately can threaten the independence of the Fed. The point here is that if central banks start to allocate credit to different sectors or to lean in to try and affect the allocation of credit to certain sectors and not others, well, this looks and feels a lot like fiscal policy or credit policy. So to put the point in a slightly different way, major structural transformations of the economy or policies that function like attacks on certain activities, well, those are fiscal functions, again, that have not been delegated to the Fed by Congress. Now, why should we be concerned about conflating monetary and fiscal policy? Well, the reason is because unelected central bankers should not be making the kinds of value judgments that are inherent in fiscal allocation. They involve making decisions about trade-offs and resource allocations in society. So when Treasury implements these policies, we can hold the president accountable. When Congress implements policies through law, we can hold Congress accountable. But like the Supreme Court, the Fed suffers from a democratic deficit and should not exercise its judgment in the place of democratically responsive institutions. So I think it's worth noting here and potentially discussing on our panel the interesting development where the FSOC, which is housed within Treasury, now has the ability to influence the Fed by issuing recommendations. And it does sort of fly in the face of a long and notable decades-long history of insulating the Fed from pressure from the Treasury and hence the presidency. So can the FSOC become an avenue for the president to influence the allocation of credit in the economy? And could this be in the direction of politically favored or away from disfavored sectors? And if that is what eventually happens, that would be an unfortunate outcome for central banking regardless of who the president is. Now, third and finally, I think it's worth asking whether we're simply giving the central bank too much to do. So much time, focus, and energy has been spent on the question of the Fed's role in climate change, while the Fed's primary, its core mandate of price stability, has gone insufficiently attended. Now, this is not to say that central banks cannot or should not multitask, but there is some inelegance in falling down on one congressional mandate while chasing other goals that Congress has not asked the Fed to do. So thank you, and I'm sure we will no doubt have a lively discussion about all of these points.
Thank you, Professor Skinner. That was very enlivening and helpful. Professor Kress, you've come the furthest, all the way from Michigan. We look forward to hearing your response. I suspect you might have a different perspective than Professor Skinner.
Thanks, Jeff. And thank you all for having me. It's a delight to be here. Believe it or not, I think today is the first day that I've put on a tie in the past 2+ years. So thank you for giving me the initiative to explore part of my closet that's gone neglected since the pandemic. As Jeff mentioned, I come from Michigan. I'm an assistant professor of business law at the Ross School of Business. Before that, though, I was an attorney at the Federal Reserve Board here in Washington. I worked to implement the Dodd-Frank Act in the wake of the 2008 crisis, and my experience with the 2008 crisis really influences how I think about these issues that we're talking about today. Shortly before 2008, there were a handful of policymakers and advocates who were warning about potential risks in securitization and derivatives and subprime mortgage lending, and they were advocating for stronger oversight of those instruments. Regulators largely ignored those calls, and we all witnessed the consequences of what happened in 2008. Today, there are important questions about whether and to what extent climate change poses risks to financial institutions and to the financial sector more broadly. I'm sure we have varying opinions on this panel about the answers to those questions. For my part, I am convinced by the evidence that climate risks, whether physical risks or transition risks, are issues that financial regulators should pay attention to. And given the magnitude of the potential problem, I think a precautionary approach is appropriate for policymakers to try to safeguard financial institutions, the financial system, and investors from the potential tail risks of climate change. No doubt we'll have time to discuss and debate today the extent of those risks and the potential policy responses, but I just wanted to take a few moments today to kind of tee up how I think about these issues, the frame through which I see the topics that we're discussing today. In my view, this is not about financial regulators trying to stop climate change. This is not about financial regulators trying to allocate capital. This is not about financial regulators trying to cut off funding to any particular industry or set of industries. This is about financial regulators doing their jobs. That is, ensuring the safety and soundness of individual financial institutions, of the financial system more broadly, and protecting investors. So I want to make two broad points before I hand things over to Dr. Kupiec. The first is just to make the base case for why climate risk is a risk that financial regulators should pay attention to. Assistant Secretary Steele mentioned that the two types of risk that we think about in this context. Climate change poses these risks to borrowers and therefore to the banks that borrow from them. First, we have physical risk. Physical risk is the risk of acute or chronic weather disasters, whether it's flooding or drought or chronic sea level rise. That could impose losses on, cause damage to property or to companies that operate in high climate sensitive regions. The second risk is transition risk. This is the risk of changes in consumer behavior or changes in government policy in response to climate change. So you could imagine consumers no longer wanting to live in coastal areas. As a result of climate change, that could cause coastal property values to drop, imposing losses on insurers or banks that hold mortgages on those properties. Those two risks, physical risk and transition risk, are very real and they're economically meaningful. We know that they're economically meaningful because the market reacts to them. We've seen bond spreads rise, yield spreads rise for companies and for countries that are highly exposed to climate risk. Depending on which of the academic studies you look at, bond spreads are somewhere on the order of 100 to 200 basis points higher for issuers that are highly exposed to climate risks. And credit rating agencies respond to climate risks as well. Issuers, whether it's companies or countries that are highly exposed to physical or transition risk, have been downgraded by all three major rating agencies because potential future climate change and policy responses in response to those climate change renders the issuer's creditworthiness in question. So climate risks are real, but there is reason to be concerned that banks and other financial institutions may not always internalize those risks, right? So this is the case for having government oversight of financial institutions with respect to climate risk, and it's pretty similar to the base case for government oversight of finance in general. Banks and other financial institutions benefit from a whole host of government support in the form of government subsidized deposit insurance, other implicit and explicit government backing, and therefore we think that financial institutions do not internalize the full costs of their risk-taking. I think that worry about moral hazard is particularly acute in the climate change context because if the worst-case climate projections materialize, there's a non-zero chance that financial institutions will not have to internalize all of those costs. Some of those costs could be offloaded onto the public sector in a worst-case climate scenario. So I think that is the high-level case for why this is something that financial regulators should pay attention to, and we can talk about, what form that government oversight might take. But that brings me to the last point I wanted to make before turning things over, which is really just to contextualize the steps that the Biden administration and the independent financial regulators have taken to date. Assistant Secretary Steele listed a lot of the initiatives earlier, and with all due respect to him, I would like to suggest that these are pretty modest steps so far, at least in respect to what some other countries are doing and what some independent financial coordinating bodies are doing. Things like the NGFS, the Network for Greening the Financial System that Professor Skinner referenced before. What the U.S. agencies and the Treasury Department are doing so far is largely along the lines of climate risk management oversight. The OCC and the FDIC have proposed climate risk management guidance for large bank boards. We've also seen initiatives and executive orders that Graham ran through about data collection, coordination, reporting on potential risks. We also have the SEC climate disclosure proposal that again is about generating information and disclosure. These initiatives do not go nearly as far as some other countries that are doing binding stress tests of their banks that would set capital requirements for climate-sensitive exposures for banks. Does not go nearly as far as central banks like the Bank of Japan that are proactively providing financial incentives for their banks to green their portfolios. Those types of initiatives are simply not on the table in the United States right now. So I think that context and comparing where the United States is to other countries and other international coordinating bodies is just helpful background to set the stage for today's discussion. So with that, I'll hand it over, and I'm looking forward to further conversation. Thanks.
Thank you, Professor Kress. As he mentioned, he served as an attorney at the Federal Reserve Board of Governors here in Washington, D.C. Dr. Kupiec, before joining AEI, had served on staff at, I believe, FDIC, as well as IMF.
And a decade at the Federal Reserve Board.
And a decade at the Federal Reserve Board. So we've got a lot of experience here on our panel. I suspect you also have some disagreements with what you've heard so far, so we'll look forward to hearing your presentation.
I think they're just all great ideas. It's very, thank you. It's very, I'm glad you invited me. It's very humbling to be a mere economist on a panel of distinguished legal minds. So, in a 2020 article published in the Cornell Journal of Law and Public Policy, my distinguished colleague on today's panel, Graham Steele, described a detailed plan to use federal financial regulatory agency powers to implement a new national industrial policy without legislation. The plan was to use the powers of the financial regulatory agencies to restrict the flow of credit and capital to firms and activities that produce greenhouse gas emissions. The outlined plan uses the Financial Stability Oversight Council to declare climate change as a systemic risk, which in turn requires FSOC members to use their Dodd-Frank regulatory powers to impose new regulations to mitigate the alleged climate change systemic risks threatening the financial system. Climate change regulations would take the form of heightened capital requirements for banks' loans to greenhouse-intensive firms and activities. These higher capital requirements would be justified by claiming that climate change factor elevate the future credit risk profile of targeted borrowers. According to Mr. Steele's article, to limit greenhouse gas emissions, regulators would also increase minimum collateral haircuts and margin requirement on capital market transactions and place new regulatory caps on the total amount of greenhouse gases that could be admitted by firms whose security are held by mutual funds, pension funds, public investment companies, and insurance companies. These caps could require divestitures. These new heightened regulatory restrictions would be applied to counterparties from specific targeted industries. As it turns out, time has revealed this plan to be the actual blueprint for implementing an important component of Biden administration's net zero policies. A cardinal rule of financial regulation is you can't regulate a risk unless you can measure it. The measure in this case will be provided by the SEC. Its March proposal requires all public companies to periodically disclose their Scope 1, 2, and 3 greenhouse gas emissions using the GHG protocol. Public companies' Scope 1 and 2 emission estimates and eventually their Scope 3 estimates must be certified by an appropriate third-party climate change consultancy. This is marketed as a measure to satisfy the information needs of confused ESG investor community, but the rule only focuses on GHG gas emissions and neglects other ESG investor causes championed by ESG investors. This plan uses the ambiguous language in the poorly drafted Dodd-Frank Act to hijack financial regulatory powers to disrupt non-financial companies that are disfavored by the current administration as a means to implement a new national industrial policy. The plan is an abuse of executive power. It usurps powers vested in the duly elected representatives in Congress. Following the 2008 financial crisis, the Dodd-Frank Act created new financial regulations designed to mitigate financial systemic risk. But by oversight or design, the Act never defines systemic risk, notwithstanding the fact that it's mentioned 39 times in the 849-page legislation. The Act requires the Federal Reserve to impose new regulations to mitigate the systemic risk created by large, complex financial institutions designated in law as systemically important financial institutions. It also allows that, by virtue of their corporate structure, activities, or practices, other financial institutions could be sources of systemic risk if so deemed by the FSOC. By never defining the term systemic risk, the Act creates ambiguity the FSOC can exploit to designate institutions' activities or practices as a source of systemic risk, a designation that requires federal financial regulatory agencies to promulgate new regulations to mitigate the risk. True to plan, the administration has capitalized on this loophole by having the FSOC conclude that climate change is a systemic risk to the financial sector. Keep in mind that Congress never granted the executive branch or independent financial regulatory agencies the power to regulate non-financial firms. The systemic risk provisions of the Dodd-Frank Act apply to federally regulated banks, financial institutions, and to non-bank financial institutions designated to be systemically important by the FSOC. The latter must be non-bank companies predominantly engaged in financial activities. The FSOC report on climate change risk essentially argues that the companies emitting greenhouse gases are the ultimate source of systemic risk, but these companies are predominantly non-financial in nature and consequently not subject to the provisions of the Dodd-Frank Act. The administration circumvents this problem by arguing that they have not designated the emission-intensive firms as systemic, but instead have determined that these firms carry heightened credit risk as a consequence of so-called climate change transitional risk. Transitional risk is a hypothetical credit risk multiplier linked to greenhouse gas emissions. Transitional risk is the risk that a firm's revenues or costs could be negatively impacted by future government policies or regulations, or because diminished demand as a consequence of changing consumer preferences. The ambiguous concept of transitional risk is wholly conjectural and not based on specific historical experiences. The concept of hypothetical transition risk could be and can be applied to any firm to justify any political goal. As I mentioned, I have 10 years working in bank regulation at the Federal Reserve Board, 10 at the FDIC, where I was chairman of the Basel Research Task Force of the Basel Committee on Bank Supervision, and I spent 5 years in the IMF in the Bank Supervision Department, where I did stress tests throughout the world, including for the FSAP exercises. It turns out that weather-related events, first of all, they're the business of insurance companies to manage, so I'm not sure why weather-related events are something we ought to focus on right now. There are numerous studies that show that weather-related events do not cause bank insolvencies, and they might cause temporary losses in banks, but they're typically made up when new loan demand to rebuild the area that the weather-related event has happened generates profits for the bank. And the newest study on these things are by the New York Federal Reserve Bank, economists at the New York Federal Reserve Bank. Climate change stress tests are the favored regulatory tool of those who fear Greta Thunberg's ire and hypothetical climate change transition risk. In these stress test exercises, regulators force banks to estimate the losses that they might accrue in the distant future should climate change somehow catalyze the modern-day equivalent of an Old Testament plague unleashed on the Egyptians, and in that event, in turn, would trigger government policies or demand changes that limit GSG-intensive industries' ability to continue operations. The Fed, an institution that time and time again has proven it cannot forecast the inflation rate or GDP growth over the next 3 months, let alone years into the future, gets to decide what level of individual bank losses are accurate in these hypothetical climate apocalypse scenarios. The Fed is also the judge of whether the banks will have sufficient capital in the future to absorb these fictional losses. Banks cannot dispute the assumptions of the Fed's imaginary catastrophic scenario, nor can they dispute the accuracy of the Fed's bank-specific loss estimates because, as a practical matter, the stress test exercise is repeated on a periodic basis, and in the next round, the Fed will still be that bank's regulator. If, as a matter of legal convention, we do not convict alleged speeding violations when the traffic radar measurement has not been certified accurate, how can we convict banks of regulatory transgressions based on estimates from a Fed-run econometric simulation exercise whose accuracy cannot be objectively verified? Common sense suggests that such rules invite arbitrary and capricious exercises of power, and indeed the courts have upheld this common sense view. In 2014, the FSOC designated MetLife, Inc. a systemically important non-bank financial institution based on a hypothetical stress test analysis. The FSOC argued that should MetLife policyholders experience a loss of confidence in MetLife, MetLife could experience a bank-like run among its policyholders. The run could trigger MetLife's bankruptcy and create widespread losses for other financial institutions. Despite the fact that there was no historical evidence that any insurer similar to MetLife had ever experienced such a calamity, because insurance company policyholders don't run like bank depositors, the FSOC insisted that this narrative provided conclusive evidence that MetLife posed a systemic risk to the financial sector. MetLife fought the designation using the Administrative Procedures Act and successfully prevailed when the court found the determination to be arbitrary and capricious. The use of climate change transitional risk to impose extra-legal regulatory sanctions on specific industries and activities repeats a previous Democratic administration's abuse of financial regulatory powers. In the illegal Operation Choke Point, the Obama administration's DOJ teamed up with the FDIC under Chairman Gruenberg to pressure banks to cease doing business with, among other industries, gun shops, payday lenders, and legal purveyors of fireworks and pornography. The justification was that such businesses had a heightened probability of being involved in money laundering and other fraudulent activities. Authorities argued that when these activities are discovered, a bank will suffer damage to its reputation, which could negatively impact its business, as well as invite regulatory sanctions for violating anti-money laundering regulations. When the legality of Operation Choke Point was questioned by Congress, the DOJ abandoned the operation. A group of payday lenders subsequently sued the FDIC, arguing that the FDIC illegally used regulatory guidance regarding reputational risk, and I quote, as the fulcrum for a campaign of backroom regulatory pressure seeking to coerce banks to terminate long-standing mutual beneficial relationships with all payday lenders. A D.C. federal court denied the FDIC's motion to dismiss the suit, and the plaintiffs won a settlement in which the FDIC admitted that certain employees acted in a manner inconsistent with FDIC policies with respect to payday lenders. It looks like Chairman Gruenberg may be a repeat offender. Like this historical abuse of the ill-defined concept of reputational risk, using climate change transitional risk as a justification for choking off lending and capital to companies involved in activities that are illegal but disfavored by the current administration is an abuse of regulatory power. Just to sum up quickly, there are three ways that if they happen to do this, it might be overturned. One is to use the Congressional Review Act. I think you guys probably know what that is. Another way is if the Republicans carry the midterms, the next Congress could pass a law. Unfortunately, both of these approaches would have to be signed by the President. They'd have to carry both the House and the Senate and be signed by the President, and I doubt President Biden would go along with that. But as MetLife demonstrated, an FSOC systemic risk determination can also be successfully challenged under the Administrative Procedures Act. This, of course, takes time, imposes significant costs on a plaintiff, and requires a plaintiff to have legal standing. I will leave it to the experts to argue who might have legal standing in this situation. Still, the point remains that the FSOC can be beaten. Thank you.
Thank you so much, Dr. Kubiak. That was very insightful, and I appreciate the remarks of our entire panel. We'll now turn to Q&A. As I said at the outset, I'd encourage the audience to begin considering questions you might like to pose to our panel. We'll have time for audience questions here shortly. But to start, let me ask our panel, and perhaps Assistant Secretary Steele, I'll start with you, and then ask Professor Kress to supplement the response in any way he'd like to. Let me begin with this question on legal authority. We've, I think, heard from most of our panel members some questions about the underlying legal authority for a host of these actions. Assistant Secretary Steele, when you look at the financial regulatory tools in the toolbox that the Biden administration is deploying, do you worry that some or even all of them are on the outer edges of current legal authority? I know you're at Treasury, so you may be limited in how many other agencies' powers you can speak to, but what do you say to those who argue that Congress has not authorized Treasury to use its authorities to try to address climate change in this manner?
I mean, the short answer is yes, we feel very comfortable with our legal position, particularly in the actions that we've taken so far. And you're right, I won't opine about the independent regulatory agencies and what their authorities are, but I'll sort of go through what FSOC's allowed to do under Dodd-Frank. Its statutory duties include collecting information from member agencies, monitoring the financial services marketplace for threats to financial stability, making recommendations to enhance the stability of U.S. financial markets, recommending supervisory priorities to regulators, and identifying gaps in regulation that could pose risk to financial stability. This is essentially what the FSOC is doing, asking for information, trying to get an empirical foundation for what the potential climate-related risks are that are out there, and then potentially making recommendations to these independent agencies. They might consider pursuing additional steps to address those, but we feel well within the bounds of what Dodd-Frank permits the FSOC to do on that score. Also, talk about FIO for a minute. I mean, FIO's authority is to identify regulatory gaps that could contribute to a systemic crisis in the insurance industry, to consult with the states regarding insurance matters of national importance, and to advise on major international insurance policy issues. Again, what FIO is doing is asking for information, doing public engagement, trying to actually measure what are the risks, what do they look like, to then assess what the magnitude is and what might be done about it. So it is very much in a data gathering, empirical foundation laying stage right now, and I assure you there's no predetermined outcome in our minds about where people want to go with this. It very much is a scoping exercise. And again, I want to emphasize the private financial sector is already doing a lot of this work themselves. In some cases, we are supplementing them. In some cases, they have actually affirmatively asked us for reliable data in a standardized format that market participants can actually examine to better understand the risks themselves, because some of them just aren't in the position to get this information and make rational decisions about what the risks are that are out there. So it is very much, we feel, number one, that it is very much within the bounds of our statutory authority, at least in the Treasury Department, and that we are very much in line with what is happening in the marketplace as well.
Professor Chris?
Yeah, I think I would just add, when I think about these issues, I go back to something that Senator Brian Schatz used to say when he was on the Senate Banking Committee, which is risk is risk, wherever it comes from. In this case, it happens to be coming from climate change. I am sure that there are folks sitting at the Federal Reserve and at the other banking agencies and the Treasury Department today who would prefer not to be thinking about climate models and what happens if we hit 2 degrees warming. I'm sure they'd rather be thinking about bread and butter financial issues, but we live in a world where risk is risk, and climate change has become a risk that banking regulators and other financial regulators have to be cognizant of in order to fulfill their statutory mandates to ensure the safety and soundness of financial institutions and the financial system.
Professor Skinner, what do you think? Are these modest initiatives by these financial regulators, or are these sort of on thin ice?
Yeah, so really good question about the nature of the legal authority and interesting responses so far. I mean, I think there's an important issue to disentangle, which is the question of whether there's legal authority, and I spoke mostly about the Fed, and I'll probably limit my remarks mostly there, and then also whether the delegation itself is proper, which is more of sort of a rule of law question, and whether Congress has some of the blame here, right? So I guess 3 points to add on this legal dimension. So we've talked a lot about financial stability risk. You know, Paul questioned where is the definition of systemic risk, and likewise, I think from a legal authority standpoint, you know, I think we're challenged to find where in the Dodd-Frank Act the Fed actually has a financial stability mandate, right? So it doesn't, right? It's been sort of implied from its historic role, but that means that it's been able to balloon a little bit. And so that's a question where I would say legal authority taken on the basis of a financial stability risk. There's this factual question that I went through in terms of the balance sheet, but then there's also sort of where is the express authority, and if it's not there, right, do we have to worry about sort of creeping or ballooning authority? And I think that's a real problem, and I think that Congress and the Fed really need to wrestle with this. If you look at other central banks like the Bank of England, you know, they do have an express financial stability mandate, right? So we can argue about whether certain policy initiatives taken pursuant to that mandate are wise or not, but nevertheless, they have the clear legal authority. So when you compare the actions taken between the two central banks, it's quite a different posture that we're arguing from. So that's financial stability risk. You know, then there's the question of the FSOC's authority to recommend actions on the basis of the financial stability risk to the Fed. So there is legal authority, right? That's written into the Dodd-Frank Act. That's how the FSOC works. Nevertheless, I would say that we potentially have a rule of law problem, and maybe we should ask whether Congress made a mistake, right? Because against this sort of backdrop of this very long-standing history of a concerted effort to make the Fed statutorily insulated from pressure from the Treasury, because before 1950, when the Treasury could pressure the Fed, things didn't really work very well. So that's a question where there's legal authority, but there's nevertheless a question of whether it's proper in this broader sort of constitutional and historical sense. I have more to say, but I think I'll stop there for now.
Thank you. Dr. Kubiak, did you have anything you wanted to add there? I would just ask, of the suite of financial measures that are being deployed, are there one or two that you find to be most legally problematic?
I would rather tell a story.
Okay.
Economists tell a lot of stories.
Let's hear it.
In summer of 2008, things were smooth. Subprime crisis was kind of brewing, but Chairman Bernanke at the Federal Reserve Board, said, this is contained. It's not going to cause a recession. That's the same Federal Board. A few months later, Lehman fails. The whole world falls apart. This is the same Federal Reserve Board that's going to decide whether transitional risk is a problem 20 years in the future and then allocate capital today. I think it is folly to think that any financial regulator has the ability or the power to, and I'm a modeler. I have published many academic peer-reviewed articles on stress testing, and I've done it for the IMF for many years and been a consultant, and I oversaw the operations of the FDIC where we looked at banks' risk and stress test models. There's no way that we're fooling ourselves if we think we can accurately assess the credit risk caused by so-called transitional risk, that the government might do something to outlaw some greenhouse gas activity in the future, and that's going to create, what do they call them, assets that are no longer useful. There's a term. Stranded assets. Thank you. So, I just think back to the last financial crisis and just the Fed's performance in forecasting inflation in the current environment. Give you a lot of confidence. Do you think this is a good idea?
Can I ask a question, Paul? So, Paul, I'd be curious, what level of precision or accuracy do you think would be necessary to intervene? And I'll just say that when I think about these issues, I don't think about the middle of the bell curve, like the most likely outcome. I think about financial regulation from the perspective of tail risks.
I think I've heard of that before.
I'm sure you have. It seems to me that when thinking about projections, we should be focused on those tails and not the middle of the bell curve. What do you think?
Well, if you're kind of thinking about cost benefit here, so the question here is, well, we really don't know. Maybe we ought to be conservative. The estimates using the EPA's model are if the Biden administration hits its net zero policy, that in the year 2100, according to the EPA's model, the average global temperature will be 0.17 degrees Celsius less than it would be otherwise. That is essentially background noise. The variability in the average temperature year to year right now is 0.11 degrees Celsius. So we're going to do all these massive things to impose all kinds of new things to choke off capital to industries that are productive and that people need the resources from. People need fossil fuel energy. And we're going to do that based on the best estimates that said that the temperature's going to decline a very tiny amount as a consequence of all these, even if all our estimates are correct. So you're putting a lot of faith in some kind of tail estimate that isn't really there. You can't quantify these things with the current science in any degree at all, to the degree that would justify these kinds of rules.
Professor Kress, do you have any thoughts on that?
Yeah, I guess I'm less interested in the delta on the temperature change about what happens whether we
Isn't that
enact
the point,
policies or
though?
not. So you were talking about 0.17 degrees if we enact policies versus if we don't. I'm asking what happens in 2100 regardless of whether we enact mitigation policies or not, and how does that affect borrowers and what happens to the financial system as a result.
But if the temperature outcome is essentially unchanged, whether you put all these regulations in place where we trust unelected officials to decide who gets capital and who doesn't because they're guessing credit risk at some point in the future might be elevated, and that might be a problem, but they really don't have any solid evidence. I don't see how you could defend something like that in court, and secondly, I don't see why you would, as a common sense individual, decide that that's the right way to go.
So I think we're talking about two different dependent variables. I think you're talking about temperature, and I'm talking about risk to the financial system.
But if you're not mitigating
Can
We're
I
gonna
hop
jump in
in?
over
Can I
here.
hop in here for a sec? And actually, Jeff, take it back to your original question, which I think was, is this stuff legal? Not, is it hard? Because, the law says we're supposed to think about what the emerging risks are, whatever source they're coming from, try to anticipate it, try to make recommendations about how to mitigate those risks. And yeah, I mean, it's hard to figure some of this stuff out. That's why we're asking for all the data that we're asking for. That's why we're working both with independent financial regulators, but also other agencies like NOAA and EPA that have background in some of this stuff to try to better understand what the climate modeling looks like. That's why we're asking for all the data we're asking for. That's why we're writing all these multi-100-page reports, is because it's actually hard to quantify and figure out, but the law says we feel we have to do it. And so that's what we're doing. So I take your point, yeah, it's hard. I think the way we look at it is we got to get our arms around it then, not we just sort of throw up our hands and say, well, life is pointless, whatever's going to happen to us is going to happen to us. So to get back to your original point, the law tells us we've got to think about emerging risks. That's what we're doing. We feel like we're on a solid legal foundation to do that.
Professor Skinner?
Okay, so I want to offer a couple of points that might make our sort of help us be concrete in a different direction and maybe give us a framework for thinking about this issue of credit risk and tail risk and emerging risk and so on and so forth. And I think to do that, it's helpful in some ways to compare 2008 because also this sort of simultaneous drop in the housing market was also what we would have considered a tail risk as well. And there are a couple of reasons why I think climate risk is distinct from that economic environment and that shock. So the first is that if you looked at banks' balance sheets, their exposure to mortgage-backed securities and mortgage-backed security-related products was there. You could see it on the balance sheets, and there was a lot of it in some of these financial institutions. The issue with climate risk is more difficult to discern, right? You're either looking for banks' exposure to the heavy carbon emitters, and then the exposure looks quite small, or you have to adopt the philosophy that climate risk is in everything. But if that's the position you want to take, then I think it's very difficult to suggest that climate risk is distinct from any number of potential risks, like nuclear, war, or immigration, or frankly, banks' exposure to malls, for example. So that, I think, is different. We can wrap our arms around that. I mean, the other thing that we have to factor in when we're thinking about credit risk is also the bank's resilience and their ability to withstand credit shocks, right? So there are lots of credit risks that we might not know about right now, but ultimately what we need to think about is how resilient are the banks to those shocks in terms of what is their loss-absorbing capacity through capital, and banks are much more capitalized, much more resilient than they were before 2008. And so I think, it's smart of regulators to think about this question of how resilient are banks to any risk, right? Climate risk or any other. And then finally, I think it's important also to parse out banks' incentives to manage a particular risk. So Graham was talking about how the private sector in some ways is leading initiatives and you're sort of on par with them. And I think that's also really distinct from pre-2008 because you do see the private sector thinking about this, and banks are not blind or uncaring about their credit risk. They are and need to be prudent risk managers too, and you see them trying to prudently manage climate risk as best as they can, which is not what was happening before 2008. So I think that this doesn't answer the questions, but the relative comparison is maybe something to think about.
Wanted to ask, companies have for a long time had to disclose a range of risks, including environmental risks, a whole range of environmental risks, and regulatory risks that may be out there. How is this different? I mean, if you have an administration or government that may be focused on adopting a whole range of new regulations that could present financial or economic burdens on industries or drive energy transition, how is this kind of risk different than those? And Professor Kress, maybe I'll start with you.
So with the caveat that I come at this largely from a banking angle and not a securities law angle, the way I think about this is, large investors, many investors, are saying that this information is relevant to them and they would like issuers to disclose this information. And when I took securities law back in law school, the definition of materiality was, would a reasonable investor consider this information important when making a decision whether to invest? So I think that when you've got particularly significant institutional investors saying that they want this information, that's something that the SEC should take into account when directing issuers what to disclose. So that is my banking law take on a securities law issue.
Anybody else on our panel want to speak to that?
Yeah, the notion that 1.3 trillion investors or whatever, there's a couple of large groups that are really advocates of ESG investing, and they got signatures for a bunch of people, and that's where the 1.3 trillion comes from. They're the managers of a bunch of groups. I mean, I don't think there's individuals out there in the world that individually would demand ESG data. Do you read the disclosure data that comes in your mailbox now on your investments? I throw mine out. I don't know about you. So we're going to have another whole bunch of. Does anybody here
You're
read
asking
the
the wrong
disclosure?
crowd. I actually do.
Does anybody read your disclosure?
Yeah,
I don't
sorry.
think so. I'm an economist. I don't read them. And we're going to have more of them now, and they're going to be very specific on greenhouse gas emissions and how they're going to affect the way I invest. Not at all, but they're part of a bigger plan, I think. And I think you laid it out, Graham, in your 2020 corner. I thank you for writing that. You just had the whole roadmap there. I just read it too late. That's all.
Again, I'll invite audience members to come to the microphones, and we'll be glad to take some questions. Let's start with the gentleman in the very back.
First, I thank all the panelists. I've learned something from every one of you that I didn't know before I walked in the door, so thank you very much. My question is really to Mr. Steele. Thank you for being here, laying out what the administration's doing. My question about all this, the problem that I have with it and the question that I have about doing all this is, if you had the science exactly right and you had the risk exactly right and you made sure that the banks didn't invest in the coal plants and the digging out the coal and all the various things, it strikes me that because your remit, to use the word Professor Skinner used, is only the United States, I think that China and India, they're not going to stay poor. They're going to build all those things, and so we don't change the actual structure of whether there's global warming or whether there's risk or not. Because even if you're not invested in those and governments turn against those, if we're not in them, it doesn't stop the climate problem that you're saying is starting the risk. In other words, I don't think the lever changes the level of what you're trying to affect.
Well, let me start by just questioning the premise of your question itself, which is this is not a lever that we're trying to pull to make anybody do anything. Again, this is a risk-focused exercise, trying to understand how climate change, how we think it might come to fruition itself, then what the potential financial transmission mechanisms are of that, so then sort of how the risk will materialize. So there's no lever being pulled. It's sort of what is our response going to be if there are climate-related financial risks, I would say. And then on your point on international coordination, I mean, we are actively engaging at places like the Financial Stability Board on these issues, at IOSCO, the securities regulators, at IAIS, on the insurance front. So there is very much an international coordinated effort here. Again, I think Professor Kress said it, that a lot of these other, in the EU and other places, number one, they have different legal mandates. So they come at this issue differently. They have different legal authorities. And we are very much behind them in the way that they are thinking about these issues. So we are really trying to catch up. A lot of them have really been doing this work for a number of years before we have been doing them. So there is an attempt at international coordination, but again, all this comes back from the statutes that we are subject to under U.S. law, so we can't implement any of that stuff. I mean, we may not be able to implement some of those pieces of it, but fundamentally it's got to go through U.S. law, be subject to judicial review, APA review, all those sorts of different things as well.
Thanks.
If I could just build on that really quick, because I do think the international context is important and is something that I worry about with other countries, some of which have different legal mandates, taking more proactive steps to limit climate financial risks in their jurisdictions. Could that lead to climate financial risk migrating across borders to the United States? Does the U.S. financial system become the go-to source of financing for climate-sensitive borrowers? If we don't catch up, I think that is a potential outcome, and it's something that I would worry about if I were sitting in Graham's seat right now.
Here at the front.
Thanks. 2 quick facts, then a question. I work in the securities market, so I am very cognizant of what's going on in financial regulation. Now, first, Warren Buffett is a well-known Democrat. He is certainly no tool of the right. He was asked within the last 2 years if there was anything on the climate change menu that was affecting insurance rates at Berkshire Hathaway, and his answer was no. And he is the gold standard as far as I'm concerned, and someone I'm much more ready to put my faith in than the federal government or the Fed. So that makes me wonder that when you go into all these companies, for example, the banks that depend on having a federal charter, and you, quote, ask them for information about climate risk, whether that's really a good faith interest in getting the facts, or whether you plan to twist their arms off to produce those facts, much as we've heard several stories about how you twist the bank's arms off to prove that they are racially discriminating. The second point is about what's going on in Europe, since you're all very interested in the international context. Listen to any speech given by Christine Lagarde, and you realize you don't have to look back to counter past examples about making errors or about inflation in the United States. All of her speeches are about how the failure to take into account the need for fossil fuel is strangling the European economy and is going to put them into a recession, which will be a depression if they have to cut off the use of the fuel from Russia. So here's the question. We have 2 ways of looking at the current menu of activity that you've put on the table. One is as good faith effort by regulators to determine knowable risks, and the other is as a sort of religious political effort by a group to change the scope of government dramatically. And I'll ask Mr. Kress, can you honestly say that we should accept the former as the explanation of what's driving all of this rather than the latter?
So I didn't come here today with the expectation that I would change anybody's minds. But I can tell you that from where I sit, I believe that physical risk and transition risk is real. I look at market signals, including bond spreads, yield spreads, credit ratings, and I think that there is something there that is worthy of financial regulators' attention. I lived through Operation Choke Point that Dr. Kupiec referenced, and this is not about reputational risk. This is not about allocating capital. This is not about curtailing funding to any particular companies or industries. The modest steps that Assistant Secretary Steele ran through are about risk identification and risk management at this point.
Could I just add on to that briefly? Not on which version of the story is right per se, but I would say that maybe the market signals are not as clear as one might think they are, because there is a decent amount of noise, I think. So, and it's worth noting that I think a lot of the market signals that we're referring to are themselves institutions that could be part of a viewpoint that we should be lending to certain industries and not others. And I think credit rating agencies is an example of that, right? So rating agencies come up with their own metrics by which they judge the riskiness of assets, and that may or may not be sort of like a pure market signal, so to speak. I'm going to talk about this a little bit later at the dinner time panel, but you know, while it's worth crediting market signals and what institutions are doing, they're operating in the context of a lot of regulatory attention and energy in one direction, and so it's hard sometimes to know whether institutional action is leading or whether it's responding to regulatory pressure, and I think you could say the same thing about rating agencies.
Up front here.
If there is nothing wrong with Treasury, the SEC, and the Fed branching out into climate policy, and in fact it's so important they have to do it, will there be anything wrong in the future when EPA or NOAA or any other government agency decides their issues of the moment are so important they have to branch into banking and securities regulation?
I'm going to ask Professor Kress if he'd like to answer the question.
Sorry.
You know, being the one of us who's not in the administration, I feel like I'm getting I also noticed that they put Graham and me on opposite ends of the panel, so we can't pass notes to one another. You know, I'll say number one, I'm happy for anybody who wants to get interested in financial regulatory policy to get interested. My worry is that not even financial regulators have been paying attention to financial regulatory policy recently. So I think my concern is not enough rather than too many. I guess I'd be interested in, you know, what exactly the hypothetical is, how NOAA or EPA might get involved. I think there's ample room for coordination that I'm sure you know, Treasury is thinking about. There should be more climate scientists talking to financial regulators and the other way around. But I think without a more concrete hypothetical on the table, I'd you know, hesitate to speculate on the propriety of any particular government agency getting involved in specific ways.
Anybody else want to speak to that topic? No. Let's go to the back, and then Myron will come up.
I'll say a word.
Yeah, sure.
I can't tell you about the EPA, but I can tell you, and I think we all know, the state governments are pushing back. There's a very nice letter drafted by Utah representatives, and I think you've probably seen that in the press, where they really push back on ESG ratings, which is all part and parcel of this, and how they don't think rating agencies have any business of, they call them political ratings, and not have anything to do with credit risk. And I think that's evidence that, you know, some other government agencies might not be so happy about sharing this kind of, or even living under this kind of regime.
In the back.
Thank you. So in terms of looking at the yield spreads, which is, I suppose, a fairly objective measure you can use, isn't there the problem that the risk is really just of the government imposing incredibly burdensome and potentially completely unjustified regulations, and so you're actually just forcing them to take into account the harm that you will do in the future? And to the point of other potential danger events that I think Professor Skinner raised, like what about nuclear war? I mean, does that, you know, maybe you could argue that that affects some industries worse than others, or it affects all the same? Would you, for example, you know, take into a scenario where the United States could face, you know, hyperinflation because of the climate policies, a collapse in the energy supply, which will still be hydrocarbon based, rolling blackouts, abolition of the police, instruction of children in elementary school in psychosexual disorders and pedophilia, expropriation of property. Would you take that into account? Basically a democratic sweep in 2024. The company should have to see what their risk exposure to that is. And isn't that much more likely than some kind of climate apocalypse 100 years from now or 80 years from now?
Dr. Shapiro, I think in your remarks you got to this point of a lack of definition of systemic risk. I think that gets to the question that's been asked here. Do you have any thoughts in response?
No, I didn't really follow the question. I couldn't really
It could
hear.
be a host of a variety of global phenomenon and issues and concerns that could come up that could create risk for the financial markets. Where does it end, basically?
Yeah, be careful if you say nuclear war is a systemic risk, they'll get a capital requirement for it pretty soon.
Any other comments from our panel?
I just want to be clear. Nuclear war is a hypothetical. Climate change is a thing that is currently happening, and so I would sort of put those two things in different buckets.
Climate change. NASA, if you look at NASA website, this so-called browning of the planet, it's greener than it's ever been. That's on the NASA website. They have pictures from the satellites that show that the planet is actually greener now than it was a few years ago with a higher greenhouse gas emissions. So this whole notion that we're witnessing climate change in real time, I think is fake news. Maybe the Homeland Security can take that up, false information.
Our question here up front, Myron.
Thank you.
Microphone, George.
Well, my question actually is in some ways an elaboration of the previous question. I think what we're talking about here is two incommensurate risk fields. Climate change, if you read the reports, the IPCC reports, the National Climate Assessments, not the summaries, but the actual chapters, if you read them, you will see that the climate change risk is over a very long period of time, 100 years. Some of these models go out to 2,300 to come up with scary numbers about, well, that can't possibly affect current financial institutions. There's no risk there. What the risk is what you, Dr. Kupiak, called transitional risks. That is energy policy, energy rationing policy. Those risks are political risks. If a company can't see those, or a financial institution can't see who won the election and what the EPA is doing and what the Congress is doing, I don't think any amount of disclosure is going to help them. I mean, they're going to go bankrupt because they're not paying attention to the political environment. So all of these regulations seem to me, and I would just put it as a statement, just seem to me to be useless. They're going to be very expensive, but they're not going to help anybody.
Professor Skinner, you made the point, I think, in your remarks that we may be asking federal regulators to do too much, and maybe they take their eye off the ball on other topics. Maybe gets a little bit to the question.
Yeah, no, I mean, I think that's certainly a relevant part to the answer. And, when you were phrasing your question, I mean, I think part of what you're getting at is that climate risk, like some of the other risks that have been mentioned, is unlike risks that regulators have been dealing with and are used to dealing with. It's in the realm of tremendous uncertainty, and even as human behavior changes and adapts, will continue to compound that uncertainty. And the problem is that regulators are trying to use their existing authorities and policy tools to address this manner of risk, which does not sit comfortably with either the legal framework or the rule of law. And so really a question is how regulatory bodies deal with uncertainty and uncertain risks. And it's a little bit like, because these current policy tools, like disclosure and capital requirements, right, they're sort of forfeits as a policy matter, and then you've got this legal challenge, which is sort of confounding as well. And it's, as I started to say, it's sort of like some of the problems that the FSOC encountered when it tried to think about insurance companies like they were banks, right? It's a different sort of thing. And I think that's a little bit of what's going on here and why you keep hearing this discomfort with treating climate risk like any other sort of problem that we've been dealing with.
Question up front.
Thank you. I want to make a couple of points first. References to Europe and the different mandates that they might have, that's completely ignoring the fact that Europe is facing serious geopolitical risks from its dependence on Russia and the rush back to fossil fuels to provide people with what they need is what is facing Europe right now. But I want to move on to a different point. It was my actual question. Part of the SEC rule refers to the fact that companies should also be able to state their transition away from fossil fuels to other sources of energy. This, for many companies, will be an impossible task because there is at present no alternative unless one wishes to use nuclear power, which most of those proponents of climate change have no desire whatsoever to do. So I leave that aside. There is no alternative source of continuous energy supply, and the transition that Assistant Secretary Steele should seriously be considering and funding is, what are you going to provide by way of continuous energy supply, which is needed not only by banks, not only by certain companies, but also by the provision of public services such as drinking water, such as required by hospitals, particularly perhaps for a surgeon in the middle of an operation, knife plunged into your body and the lights go out. Hospitals at the moment are able to fall back on their own generators immediately, which are run by diesel oil. So I think what we should think about very carefully, if we're asking companies to report on an impossible transition and not considering the risk of no transition to continuous energy supply being available as a substitute, that actually makes these regulations impossible to impose and absurd to impose.
Yeah, so the question's to the SEC proposed rule that's still under review, and its requirement that publicly traded companies disclose their energy transition plans. Any of our panelists want to comment on that?
I'll just say that I'm glad that you asked that question because it's something that I've been meaning to state in my remarks and I haven't had a chance to. I mean, I agree entirely. I think one of the big elephants in the room is what exactly are we asking banks to do? If we ask them not to lend to fossil fuel producers anymore, in the absence of an alternative, reliable energy source, it's not clear what the outcome will be. So, my view is that we're far better off trying to direct governmental resources toward researching the technologies that then the market could, in turn, bring to market and to scale. But I don't want to preempt a lot of my remarks tonight, so I have to delicately separate them. But.
I mean, I would just say my understanding of the topic of the panel was sort of narrowly cabined to some of the financial regulatory aspects of climate risk. I mean, I didn't touch on a number of what other departments are doing, other sort of fiscal programs, investments in different kinds of technology. I mean, as I said at the outset, the President's executive order says a whole of government approach, so I think the administration's not putting the eggs for all climate-related issues in the basket of the Treasury Department, just to be clear about that.
I would just chip in that the requirement that you have to discuss your plans for transition to deal with transition risk presumes that they have to have a plan. And is this now a new law? Everybody has to have a plan to transition or you can't be a public company? I mean, what happens if you say, I don't believe in transition risk? I don't have a plan. What's the SEC going to do? But does it presume that you have to have
I think you disclosed that then?
Huh?
I think you disclosed that?
I don't know. How they're going to deal. They have to discuss how they're going to deal with transition risk. That presupposes they're going to do something. Maybe they don't. Transition risk is the risk that the government will change the policy on you, basically, right? And who knows? I mean, firms have to have a plan for transition risk.
Sounds like comments to submit to the SEC. Our last question, and we're out of time. Hopefully we'll be able to get to robust answers. If not, we can talk afterwards.
Victoria Guido with Politico. Questions for Assistant Secretary Steele. I wanted to ask about, you mentioned scenario analysis as what the FSOC is doing, and I was just wondering if you could elaborate a little bit about, is that coordinating across the agencies on scenario analysis? Is the FSOC considering doing its own scenario analysis? Just kind of curious where that's at right now.
Yeah, I think I mentioned in the context of the Climate-Related Financial Risk Committee, I think a lot of what is happening there is just a conversation about how to think about that as an issue amongst a broad variety of other issues around data standardization, coordination on various regulatory measures. So my understanding is there's no specific plan right now about what to do on that front. It's more of a conversation about how different agencies are thinking about the role that might play at some point within this process.
Thanks.
Thank you. As an environmental lawyer who has engaged on the question of EPA's authority to regulate this area, I welcome our financial regulatory colleagues to this complicated question of climate change and what to do about it. Thank you for your attendance here today. We really appreciate it. And please join me in a round of applause for our distinguished panel.
Nice to meet you.